We're ready whenever you are. All rise. The Honorables, the presiding Chief Judge and Judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to North Carolina Court of Appeals. My name is Chris Dill and I'll be the Chief Judge presiding today. To my right is Judge John Tyson. To my left is Judge Fred Gore. We have Jean Soar, our clerk, here today, and Officer Salou, our marshal today. We have one case on the calendar. It's a criminal case out of New Hanover County. It's State versus, is it Southers? Am I pronouncing that right? State versus Southers. And if the appellant is ready, you may proceed and let me know if you want to reserve any time for rebuttal.
Good afternoon. May it please the court, I'm Catherine Vandenberg from the Appellate Defender's Office here representing Ray Southers, and I would like to reserve 7 minutes for rebuttal.
Okay.
This was a case with essentially one question for the jury. Why did Ms. Lopez get shot? We know that Ray Southers was holding the gun when it fired, and the question for the jury was, did he intend to shoot her? Was he handling the gun recklessly? Or did the gun fire accidentally? The jury is charged with finding the truth. Because of the trial court's evidentiary rulings, the jury was denied relevant information they should have had to determine the truth in this case.
So even if he didn't mean to do it, but he was holding it recklessly, the conviction stands. And that's what the jury found, I believe.
Well, there are two levels. There's the B2 second-degree murder,
right,
and then there's also involuntary manslaughter. And this court, I don't think we've cited these cases, but there's a line of cases that say it's really a continuum between criminal negligence that constitutes second-degree murder and criminal negligence that constitutes involuntary.
And they found malice arising out of an act which is inherently dangerous to human life. And so the question for us is whether he was denied evidence that maybe it was just an accident and didn't rise to that level.
Right, or that rose to the level that's involuntary manslaughter. I mean,
I
I
understand.
don't know how someone figures that out, but it's a matter of degree, I think is what this
It'd
court
be,
has said.
maybe,
If a-
go ahead, you go ahead.
If a human being is killed with the use of a deadly weapon, doesn't that presume malice to support second degree?
Well, there's case law in second-degree murder about that, but there are also cases where someone is shooting and there's a B2, second-degree murder conviction. So I don't think that rule applies to that situation. And then it, of course, doesn't apply to involuntary manslaughter when someone is acting recklessly.
Well, is the transcript correct when it says that he entered the victim's apartment and was told to leave with the weapon and did not do so?
There was testimony to that. The jury did not find that he entered, they found a misdemeanor breaking and entering. They did not find felony breaking and entering.
Right. But he was told to leave, and he was in the private home of the victim at the time.
Well, there was testimony about that. Mr. Southers said that these were good friends and they had a joking relationship back and forth, and I don't know if you recall all the details, but he said he didn't think they really meant it. He said what Mr. Booker said was, you need to text me if you want to come in, or something along those lines.
Was there testimony there'd been an argument between the defendant and the victim previously?
There had been, I want to say, a week or two before, Ms. Lopez had slapped Mr. Southers. Yes, there was testimony
And
about
was there
that.
testimony on the night of the killing that the victim came in and told Mr. Booker that the defendant had slapped her
I don't remember that he had slapped
or
her.
hit her?
I believe that what Mr. Booker testified to is that he saw her come falling into the room and assumed she had been pushed or shoved, and he may have said that she said something. I don't
Now,
recall
the
exactly.
state filed a motion in limine to restrict the use of the 911 call and Mr. Booker's statements to the officers, right? Mr. Booker did testify as to his impression of the defendant at the time of the shooting. Is that correct?
He testified to the look on Mr. Southers' face after the gun fired.
And did your client testify as well?
Yes, he did.
And did he offer evidence of accident?
Yes,
Did the trial court instruct the jury on accident?
yes.
So even if there was error in the motion in limine, how can you show, and we're under abuse of discretion on the admission of evidence by the trial court?
Depending on which way you're looking at it.
Right, but if it's an abuse of discretion standard where you've got to show that Judge Gorham's ruling was not the product of a reasoned decision to show prejudice, how can you do that in light that she did allow the testimony, your client did testify, and she submitted the issue of accident to the jury along with all lesser included of the first-degree murder?
There are a few reasons that it's prejudicial. First of all, Mr. Southers' own testimony is self-serving, as the state argued at the trial, right? When someone comes up and testifies, oh, it was an accident, it might be true, it might be false, and the jury has to figure that out. But without any corroboration, he's just left with his own testimony. So if on the 911 call, which Mr. Booker made minutes after the shooting, 3 years before this trial, he said, this was an accident, the gun went off, the gun discharged in my house. And then when the police arrive a few minutes later, Mr. Booker said repeatedly, it was an accident, I believe 3 or 4 times. He also said that Mr. Southers said, at the moment he shot the gun, I didn't mean to do it. So all of that would have corroborated what Mr. Southers said, rather than him just testifying on his own.
Did your client flee the scene?
Well, there was an instruction about fleeing. There was different testimony. Mr. Booker said he wanted Mr. Southers to leave so that he could call 911, and that he did.
But the fact that he left, he could have waited in the hall or waited across the street in his own, he did not do that.
But I think walking away is not necessarily fleeing.
Wasn't he apprehended in a car and he was stopped at a vehicle stop?
Correct.
And at the time he was stopped, did he deny any involvement in the shooting?
He did not speak to police at the time he was stopped and arrested. He asked why he was being arrested while they were handcuffing him.
Did he assert that the shooting was an accident
No, he did not.
at the time?
Not to police. He did tell his friend, the other person, Philly, who's not really in the picture now, and he said it immediately at the scene. to
Well,
Mr.
Philly was present in the apartment when the killing occurred, right?
He was, but he didn't testify. I think he disappeared to Philly, and they couldn't find him.
Let me ask you a question, because the jury found malice arising out of an act which is inherently dangerous to human life. I don't know this, but I would assume the jury found that because he was just holding a loaded gun pointing at somebody. So even if this evidence that I didn't mean to do it, it was an accident, how does that prejudice the jury's finding that they found, they didn't think he did it out of ill will, they rejected the ill will, hatred, spite,
And
or malice, I mean, it is malice, but it's malice.
Premeditation.
Or premeditation, but they just said he was engaging in inherently dangerous to human life. Couldn't they just have found that because he was waving a loaded gun in a room? And so why was this prejudicial? Just because the guy said he didn't do it accidentally, he wouldn't have meant it in a legal sense. He's just saying he didn't mean to do it.
Well,
I know what the jury found.
the jury found that, but that's partly because they didn't have the other evidence in front of them. So the prejudice is, if that evidence had been admitted, maybe they would have found a different verdict, right? This is all well-preserved error. So the question on prejudice is there a reasonable possibility that the outcome could have been different, right? And actually, we've also raised, and they raised at trial, a constitutional issue about the meaningful opportunity to present a defense, and the standard there is it's the state's burden to prove beyond a reasonable doubt that this evidence could have made a difference.
Now, there was text messages by your client, I think, that asserted that the shooting was accidental, correct?
Correct.
And Judge Gorham allowed those to be admitted as well.
Correct.
So you had Booker's testimony that of his perception, present sense impression of the defendant.
Of the look on his face was all he was allowed to say.
Something, in fact, it looked like he had dropped his mother's favorite piece of china.
Correct.
Something to that effect.
Yes,
And then the testimony, and then the defendant's own testimony, correct?
correct.
When your client first entered the apartment with the gun, didn't either Philly or Bob tell him he didn't need to bring a gun in there?
So there was testimony about that was
Well,
modeled.
isn't that for the jury to decide that?
Sure. That was a question.
I just want to make sure the jury has a basis to find what it did. I'm not saying it was credible or not, that's their job.
Sure. They had a basis to find anything from not guilty to first-degree murder, depending on what they believed. You know,
Your argument is there was enough evidence to show second-degree murder. You're just saying if they'd heard this other evidence, they might have found something different.
Correct.
Okay,
That's the prejudice.
So I'm still trying to get to. I still think was there testimony that the gun was pointed toward the victim? I guess is that what I mean. Would Mr. Booker have said anything different? I mean, because it sounded like all you're saying he would have said differently was he didn't mean to do it. Whatever he was doing, was there any testimony he was going to offer that he wasn't pointing the gun at her and it just kind of flung that way or anything like that? Or was it all just this was his state of mind, he didn't mean to do it?
Right. So Mr. Booker didn't say he was pointing it at her. He certainly didn't say he was aiming at her and intending to shoot her. He said it was pointed in her general direction. Now, this is I want to say 8 by 10 bedroom with a bed and a couch. It's a very small room.
And
a
three
big
people.
gun.
And three people.
And 3 people. So, I mean, the gun has to be pointed somewhere, right? And I think when he says it was in her general direction, that sounds very different to me. You know, if the 911
And the
calls,
jury heard that. That's what I'm saying.
they heard what Booker testified to.
So
yes.
why would it have made a difference in their finding that this was inherently dangerous to human life if they just heard Mr. Booker say he didn't mean to shoot her when he was pointing the gun in her general direction.
Well, in her general direction, that's not intending to shoot her. It had to point somewhere. He was holding it, right? He didn't say he meant to shoot her.
Was there also
The jury probably would have found that.
Was it also testimony from Mr. Booker that after he shot Ms. Lopez, that your client pointed the gun at his chest too?
He did testify to that, correct.
So that was before the jury as well.
It was. I don't know what they made of that. I mean, he didn't fire it, and he put it down, and he said he was sorry and didn't mean it, and he left. So,
Well, I guess when we look at, there was not instruction that your client wanted that the judge did not give, correct?
there was an instruction well, it had to do with something that the jury sent a note, and I didn't raise it in the appeal, so.
So it did not pertain to the murder
The
conviction?
offenses that were submitted, correct.
Right. Did Mr. Booker observe your client in the hallway cleaning the gun when he first
Yes,
got to the apartment?
yes. Well, polishing it, I don't know, cleaning it. He didn't have it taken apart, cleaning it that way, but that's what Mr. Booker said.
And was your client told twice to leave the apartment with the gun, both by Philly or Bob, and then by Ms. Lopez herself?
I think that was messy evidence. I think Mr. Booker is the only person who testified, and he said, somewhat different things. He certainly did say that Ms. Lopez didn't want him to be there because one of them was a felon and they weren't supposed to have a gun in the house. He didn't say, Booker did not say that he told Mr. Southers that fact. And he
Now,
was
the
asked
jury
that.
convicted your client of possession of a firearm by a felon as
They
well,
did.
correct? So in terms of, there's no dispute about that either?
Well,
You're not challenging that?
no, not challenging that.
And it wasn't challenged at the trial court?
I don't believe so. I think they essentially admitted that he had a prior felon.
If I remember the judgment correctly, Judge Gorham sentenced him in the presumptive range.
That sounds right.
There were no aggravators?
There were no aggravators. I think the jury was submitted an aggravator and they found that it didn't exist. It was putting multiple people in danger. Judge Gorham did give him, I believe, the high presumptive and ran them consecutive.
Ran the misdemeanor B&E and the possession by a felon consecutive.
Well, I think the misdemeanor B&E was lumped in with the felon charge.
And that was combined for the second sentence.
Correct, correct.
If we're under, and I'm going to ask your counsel here, are we looking at something other than an abuse of discretion standard of review?
So, depending on which precise evidentiary rule you're looking at, yes. So, for hearsay, which is the excited utterance, the present sense of impression, those rulings are reviewed de novo.
Both-
Because it's
both
either
under
a
rule-
hearsay or it is not, right?
And that's true under both Rule 701 and under Rule 803?
I believe those are abuse of discretion. Those
Both.
are not hearsay rules, right? So depending on which method of the evidence coming in you're looking at. Before I forget, I want to say one other thing about the text messages that you brought up earlier and the prejudice to them. There are two reasons that they do not help Mr. Southers as much as the video evidence. One is he sent that text over an hour later, and the immediacy of Mr. Booker's testimony, both on voir dire and on the video camera, is that he said Mr. Southers said it right after he shot. And our hearsay exceptions pay attention to that, right? That's why we have an excited utterance exception, because it's deemed more reliable, because it happened right in the moment, before someone has time to reflect and biases and motives creep in. The same is true with the present sense impression, because it's the time, right? You haven't had time to think it over. And in this case, both of them apply. It was a startling event, and it happened immediately. So an hour later, if Mr. Southers sends a text, the jury could find that less compelling. Also, the wording he used is, "I made a mistake," and I think "I made a mistake" could also, it could reflect that he was saying it was an accident. It could also reflect regret, right? It's different than "I didn't mean to do it."
Now, if I understand that the subject of the motion in limine that was filed by the state was to exclude the 911 call by Mr. Booker.
Portions of it. So the 911 call came in, but they redacted every time he said it was an accident.
Okay, so that was Mr. Booker's report to the dispatcher, correct? And then the other thing I think is the statement that he made to the officers on the scene.
No, I think well, that may have been included too, but I think it was more about the body camera footage, because there was 2 or 3 different officers had body cameras running, and they were with Mr. Booker at different times. They were all in the apartment together, and then they took him to the back of the house, and he was waiting on the porch, and there was one.
But all of this was after the fact of the shooting. This was not, this was a reflective report to both the dispatcher and to law enforcement.
Well, under our case law, 2 minutes later is not a reflective report.
Were they there that quickly?
Yeah. That's in the brief. He made the call, and yeah, she was still alive. Yes, so it certainly meets the hearsay exceptions. It's a textbook example of excited utterance and presence.
Talk about the, your objection to, or the objection when they asked the defendant about why you didn't speak to the police. I mean, when he was simply exercised, you're saying he just simply exercised his right to remain silent, and it's not right for the state to make anything of it.
Right.
I think the state would argue that the defense opened the door and all that. So how would you, tell me why this is something that we should consider?
Okay, so the second issue raises that Fifth Amendment right. The cases I submitted, Hoyle and Shores, are both factually almost exactly in line with this case, where a person gave a short or partial statement to the police early on, and then later said more when they testified at trial, and they were attacked by the prosecutor on cross, and then it was argued to the jury that, why didn't you come forward sooner? Why wouldn't you have told the police if this was true? And that is exactly what is prohibited by the Fifth Amendment. It's not that the fact of his, of what he said to police and what they said to them, that's not the part that's the problem. The problem is, and what troubles the courts is, when you suggest to the jury by saying, why didn't you say this earlier? You're coming in here now 3 years later and telling us this story. That suggests that you're not telling the truth.
Counsel, how does that balance with the defendant putting his credibility in question by taking the stand and that being fair game? How do you balance the veracity and credibility being questioned versus the accusation that you're saying? Because obviously there wasn't direct testimony of prosecutors saying you're lying, but how do you say that is crossing the line whenever it is automatic fair game to question the credibility of someone on the stand?
Well, I think it's automatic fair game to question someone's credibility, but it's not fair game to do that by attacking them for using their constitutional right to remain silent. Otherwise, there's no right to remain silent.
So do you mean that should never be asked, or?
Correct. And that point should not be argued to the jury. Don't believe this person. He should have told the police. That's exactly what the cases say that I've submitted.
So does our case law, and I'm trying to remember one that says that question should not be asked, because I don't think we have a case that says it that specifically.
Well, I think both the cases I submitted that I'm talking about, State versus Hoyle and State versus Shores, have the prosecutor saying, asking both the policeman and who the person spoke to and the defendant himself, you didn't come forward with it. Why didn't you come forward with this? It doesn't have to be word for word, but it's the same point that the prosecutor was making in this case.
The state on pages 21, 22, and 23 of their brief discusses the case of State versus Fair,
Yes.
Supreme Court case. And that was a case where there was a claim of alibi that was raised, quote, for the first time at the trial. Why wouldn't FAIR control the result here?
Well, FAIR talks about it's permissible to cross-examine someone on a prior inconsistent statement. And the test that FAIR sets out to figure out if it was a prior inconsistent statement or not, which is the question, is this. Assuming that the defendant's trial testimony is true, so imagine Mr. Southers is sitting there telling the truth about it being an accident. The test is, would it have been natural for him to say the same thing to the police in his first encounter with them? The FAIR situation was, I believe, the one where the person was talking to the press and said something about, I hope you catch him, and then later he made it a different story. And I think if you apply that test here, I don't know if you've watched State's Exhibit 102, which is his interrogation, but Mr. Southers did not make a contrary statement. He made no statement at all. He was barely coherent. His head's down on the table, and they come in and start talking to him, and he's just sort of mumbling. And, he says, I don't know anything about that. I don't want to talk to you. Get out of my face, ultimately. And the police come out of the room on video and say, yeah, he's not talking, right? So that, if we're calling that a prior inconsistent statement that allows you to mow down his constitutional rights, I think there's no right left. I mean, he just simply didn't give a statement to police that can be considered a prior inconsistent statement.
Getting ready to get to your 7 minutes.
Okay.
So,
I'll leave it there then. Thank you.
thank you. Good afternoon.
Afternoon, Your Honors. May it please the Court. Zachary Dunn here on behalf of the state. First, I'd like to thank the court and opposing counsel for rescheduling the oral argument for me, so I really do appreciate that. As this court knows, and as we've been talking about so far today, Mr. Southers murdered Jody Lopez in her own home and in front of her boyfriend. Now, this case raises 3 issues for Your Honors, but I'd like to start where the majority of the questions were for my opposing counsel, and that is the accident statements, the first issue on appeal.
Let's say this, because the statement's exclusion, Judge Gorham's exclusion based on the state's motion appears to be the central issue here, correct?
Correct. Yes, Your Honor.
And if it's under either rule, 700 or 7803, either one, what does the state contend that our standard of review is?
We think that that's an abuse of discretion standard, Your Honor. We quoted it in our brief under 701, it's page 8 of our brief, that this court and our Supreme Court in Ralph said that it's an abuse of discretion standard. So
Under both rules?
Submit, yes, Your Honor.
Okay, in North Carolina, we've also got the right to assert a defense.
Yes, Your Honor.
And the denial of a right to assert a defense, that's a different standard, correct?
I believe so, Your Honor, yes.
So his defense is it was an accident.
That's right.
So why wouldn't he be allowed to submit that evidence when there is corroborating evidence that Judge Gorham did allow?
Well, he was allowed to make that defense. I mean, there was, like you said, some evidence of accident, and the trial court specifically instructed under the pattern jury instructions on accident. But this specific testimony, or proffered pieces of evidence, is of course what I think you're talking about. And it's simply not allowed because it goes to the defendant's intent at the time of the crime, which our case law says is incompetent evidence.
Now, didn't the state in its motion in limine, didn't it assert, I'm on page 32 of the record, didn't it assert that it would be subject, that the question of intent would be subject to expert testimony, and that a lay witness couldn't assert to that? Wasn't that the basis of the motion?
I believe, Your Honor, that you're reading it. I don't have it with me at this exact second. But certainly, I don't need to see it. If the defense wanted to provide an expert witness on the defense of accident, they were certainly free to do so. But this testimony, the specific pieces of evidence, the 911 tape and the body cam footage, is incompetent evidence and not subject to lay opinion testimony. That's right, and that's under McElroy and as far back as Vines in 1885, which we think is of course it's 150 years old, but it is remarkably similar to what we have here, where defendant's counsel in that case wanted to ask the witness if he regarded the shooting as accidental, and our Supreme Court affirmed the trial court not allowing that testimony in because the jury, quote, were as competent to judge whether or not the shooting was accidental as the witness, unquote. So, as far back as 150 years ago, we have a Supreme Court case saying, this type of lay witness testimony opining on the state of mind of the defendant is not competent evidence in North Carolina courtrooms.
Do you agree that had the state or had the jury not found the instrumentality, that the defendant would have probably been at the most convicted of voluntary manslaughter? Wasn't that weapon, whether or not it was accident or not, isn't that what raised it from voluntary manslaughter to second degree?
I think so, yeah. Of course, we don't know what the jury would have done had they had this evidence. As my friend on the other side stated, there was evidence for, all levels.
Do you really believe that?
all the
So
way
if
down.
somebody just is playing with a gun and they're not being overly negligent and they shoot somebody, is it not possible that could be involuntary manslaughter? Could it not?
Or voluntary?
Or, no, voluntary is if you intend to do it. Involuntary, it accidentally goes off.
Yeah, that's
That
certainly
could be
possible.
involuntary, but this jury found that it rose to a level it was inherently dangerous, and so,
Correct.
so
And that's
there
certainly
could be a
their purview.
universe of facts where they might not find it inherently dangerous. It's just negligent, and it goes off, and you get convicted of involuntary manslaughter.
If we do review Judge Gorham's ruling under a right to make a defense standard of review, what's the state's position then if it's not an abuse of discretion?
Well, the state's position is he was allowed to make a defense. He was allowed to raise evidence of accident. There was his text messages, which have been talked about a little bit here before today. There was his own testimony saying that it was an accident, and then Booker's testimony. And it's the really key phrase. Your Honor picked up on it. Booker saying he looked like a kid that just broke his mom's favorite piece of china in the kitchen. A very memorable phrase. And then he went on to say, on questioning, that would you say that was a surprise? Booker said yes. So we have Booker saying he looked surprised. We have defendant's own text messages saying it was a mistake, and we have the trial court giving an accident instruction based on the evidence that was admitted in.
But we also have the state being able to argue to the jury, don't believe that because he remained silent for 3 years.
That's right, yes.
So why is that not a problem?
Well, that's getting into the second issue, and that's not a problem because, one of two answers I have here. One, it was invited error, and the second, he chose not to stay silent. On the invited error piece, I would point the court, it's an unpublished case, but it is published by Your Honor, Chief Judge Dillon. It's the Washington case from 2019. And in that case, the prosecutor mused that the defendant had every opportunity in the world to tell this tale that he told you today. And he said he had 2 years plus to think about this story. And this court held that any error was invited because the defendant arguably opened the door by commenting on his silence during direct examination. And that's exactly what we have here. On direct examination, Mr. Southers talked about whether or not he talked to police, why he found them non-trustworthy. And he said, I think this is transcript volume 13 at page 2010, I don't have to say anything. So he's directly talking about his silence. And under Washington, of course not binding, but we would urge Your Honors to adopt it. That's invited error. He opened the door to his silence by talking to it on direct examination. He certainly didn't have to do that, but in this case, he did. So that's our invited error argument. But to the merits, the defendant here did not choose to remain silent. He engaged with the officers. Yes, it was brief. His head was down, that sort of thing. But he talked to them on several different topics. He asked, why he was there. He stated that he didn't know anything that happened at his girlfriend's apartment. And then when asked whether anything exciting happened to him that day, again, he didn't stay silent. He said he had sex with someone. And so that is him engaging with the officers and not staying silent. And so it is fodder for cross-examination for the prosecution to say, well, you're talking to these officers, you're saying these things, even something that happened that very night, but you're not telling them that you shot someone and it was an accident. So under fair, again, something that's been brought up here today, we think that works in our favor because, this is fair. A defendant who voluntarily speaks after receiving Miranda warnings has not been induced to remain silent. Here, Mr. Southers was not silent. He engaged with the officers, but he did not tell them it was an accident. So that would be our submission on that, the second issue, the silence issue, Your Honors.
Was the evidence that was excluded, would that have added to the defendant's defense, or was it merely cumulative of what the jury already heard?
Which evidence are you referring to?
The 911 call and the accident.
We would say that it would be cumulative because of all this other evidence that did come in, including Booker's testimony. So that would be our answer, that it would have been cumulative evidence. And so apart from it not being allowed under case law, we talked about it a little bit, but the McElroy case, a witness may not give his opinion of another person's intention on a particular occasion. That is what Booker was doing. He's saying, I saw this happen. I think it was an accident. He didn't mean to do this. So that testimony is just incompetent under McElroy and other cases of this court and our Supreme Court. But in addition to that, we would say that it would have been merely cumulative.
Help me with this, because the jury verdict was, as I read the jury verdict, they essentially found he didn't mean to do it. He was just engaging in inherently dangerous activity when the gun went off. What evidence was left out? I mean, it seems like the only evidence I've heard that was left out was more evidence that he didn't mean to do it, which the jury already found. Was there evidence such that he said, I didn't have my finger on the trigger and it just went off accidentally and the judge wouldn't let that in, or I did pull the trigger, or my finger accidentally, I mean, was there anything about what actually happened that could have gotten the jury to a different place where maybe it wasn't inherently dangerous? I was pointing it up and it just slipped out of my hands. I mean, the only statements that I've heard so far was, I didn't mean to do it, which am I correct about that in your mind?
You are, Your Honor. So he testified at trial. He said it was an accident. He didn't, from my reading, of course, of the testimony, say anything that would get it out of that inherently dangerous mode. But that only works in our favor.
You're saying there was no testimony that was let out that would have said it wasn't inherently dangerous. It was just that he didn't mean to do it.
Correct.
And you would say the jury found that he didn't mean to do it.
We would. So even if, and that goes to prejudice, even if this should have been allowed in, because the jury found him guilty and under a theory where whether he meant to do it or not didn't matter, then there's no prejudice to the defendant.
He's complaining that there was evidence not let in that said he didn't mean to do it, but the jury found that he didn't mean to do it anyway. They just found that the act was inherently dangerous.
That's
but
certainly a way.
Let the defense respond to that. If there was why would that have gone to the heart of why this wasn't an inherently dangerous activity he was engaged in? And you would say that there was no statement left out that went to that particular issue.
Not that I recall, Your Honors. I believe the only testimony was Booker's and the defendant's. Booker said that the victim seemed to fall into the bedroom in such a way that she was pushed, and then within a short matter of time the gun went off, and that's kind of all she said. And then the defendant's testimony really was all about accident. He didn't mean to do it, that sort of thing. So that's from my recollection of the testimony in that case. But yeah, nothing to get it outside of that realm of being reckless, whether or not it was an accident or not. Of course, happy to answer any questions the court has, but I would like to touch on the third issue in this case, which is the misstatement of law issue and whether this court should extend McLemore into the area of accident. Our Supreme Court has set a bright line rule on accident, which is that the defense is not available where the defendant was not engaged in lawful conduct when the killing occurred. So that's sort of the baseline. If the defendant is engaging in unlawful conduct, then accident is not available to them. The Supreme Court, in a similar position, but albeit very different because it's self-defense rather than accident, our Supreme Court has said that this so-called lawful conduct bar does not apply to self-defense in circumstances where the underlying unlawful conduct is possession of a firearm by a felon, because in that circumstance, if it did, felons would never be able to defend themselves with a deadly weapon.
So if I'm lawfully carrying a gun sitting at my desk and I'm writing a bad illegal check and the gun falls out of my pocket and shoots and kills somebody, I'm not entitled to the defense of accident because I'm engaging in unlawful activity while the gun goes off. Is that what you're really telling us? I mean, that's unlawful activity. The gun goes off, kills somebody. It's an accident, but I'm guilty of murder.
I think that's the law as it stands today. If that particular case came up to this court, we might say that there should be a causal nexus between the unlawful conduct and the killing that occurred. Of course, here we argue that
Well, there is with a felon who kills somebody in self-defense. There's a causal nexus.
causal, yeah. That's what the court said in McLemore, yeah.
So why should this be different? Why should a defendant who's possessed, if he accidentally drops it, not have the accident defense available?
We think that question isn't before the court. The way I read their argument is not that the causal nexus piece, but rather the lawful conduct bar. So, right now, under Riddick, the defendant has, if he's engaged in unlawful conduct when the killing occurred, then accident is not available.
Let me ask you this, if we even, to Judge Dillon's point, the writing the check when the gun falls, you had a breaking and entering here
Correct,
that the jury convicted him on.
correct.
So you had illegal conduct aside from the felon possessing the weapon, correct?
We do, Your Honor.
And where there was evidence to the jury that he'd been told twice to leave
That's correct.
by lawful occupants of the home.
Yes. Yeah.
And that he had come in without, just, he'd entered the room, I think Booker testified, then when he knocked on the door after midnight and woke him up, he said, "Don't come in here to tomorrow." There was some statement that was clear, as far as Booker said, he wasn't even supposed to be in here to start with.
Correct. Yeah, Booker testified, and I don't know if it was Booker telling the defendant, don't come in here, or he was relaying that the victim said that to the defendant, but one of them said that to the defendant. Don't
And he
come
came in
here.
anyway.
Yeah, don't come
The door
in here.
was unlocked.
Text me if you need anything. And
The
he
door
came
was
in.
unlocked, he came in.
Correct.
And then he was confronted by either Philly or Bob, "Don't come in here with a gun."
Philly, I believe, who was laying on the couch in the living room, which is, it's a very small room. It's right as you come in the door. He was
But
laying.
at that time, Booker and the victim were in the bedroom.
We're in the bedroom, correct.
So they weren't really at risk. Well, you said small room, but they weren't at the same degree of risk.
Not at that time, no.
And then the testimony was from Booker that Lopez went out, confronted the defendant, and was either hit or struck and fell back into the bedroom, and then the defendant followed her in, correct?
Correct, that's right. Yeah.
So it's not like writing a check here. You've got a B&E, you've got someone into a private residence, which could be burglary, correct?
Correct. If he was, for instance, intending to steal their drugs, because I think that's what he was after. He wasn't convicted of that.
The jury did not find that. They specifically found that he was not committing a felony. And we do have felony murder, but if you accidentally kill somebody doing a misdemeanor, that's misdemeanor manslaughter. But the jury found malice. So you got to have malice, and malice is more than just committing a misdemeanor while you kill somebody or an accident. Because if it was an accident, then you have to show malice. So how's the mere fact that he's possessing a firearm by felon? How's that malice? How does that create the malice? Committing a felony would be and if the jury found that he committed a felony, then it would be first-degree murder. There's no felony second-degree murder. It would be felony first-degree murder.
Yes, Your Honor.
So are you asking us to create some new law that if you don't have to prove malice if he's committing some misdemeanor when somebody dies? Because we do have misdemeanor manslaughter.
Right. We're certainly not asking for any new rule. We're just simply asking Your Honors to apply Riddick, which says that if you're not engaged in lawful conduct, and here the unlawful conduct could either be possession of a firearm by a felon or the misdemeanor breaking and entering. No, Riddick doesn't predicate this
Is
rule
possession
on
by
it being
fire, is felony possession by firearm, is that a felon?
It's a felony, correct. And this other crime that he was convicted of is a misdemeanor, but the case law makes no distinction. It doesn't have to be a felony. It's just unlawful conduct. And certainly breaking and entering, whether it's misdemeanor or felony, is unlawful
But
conduct.
I thought we have felony murder as first degree. If I'm committing a felony and somebody dies, if I'm committing a misdemeanor when somebody dies, that's just manslaughter. That's misdemeanor manslaughter, unless I'm forgetting my law school.
No, I think that's right.
Okay, but this guy was convicted of second-degree murder, so this is different. They had to find malice, and so the mere fact that he's committing a misdemeanor does not elevate it to a malice killing under
Right.
case law.
But this inquiry is only going to whether or not the defense of accident was available to him, not really the degrees of murder and what was shown.
Well, if it's not available to him, then all we have is that it wasn't an accident, he meant to do it or something. It's malice. I mean, if you have an accident, then there's no malice. If it's the legal accident,
Correct.
not a, he didn't mean to do it, but if it.
Counsel, I guess
wasn't
the question,
Go ahead.
question I would have is then if, on the malice issue, which is the admission of the conduct by the defendant is not being challenged, what's being challenged is counter evidence to corroborate additional. But was there evidence in the record as to how he handled the firearm to allow the jury to make that finding?
There's not. So the only evidence of how he handled the firearm was, as Judge Tyson said earlier in the week, he was cleaning or polishing the gun. And then, from my recollection, the only other evidence was after he shot Ms. Lopez, he turned the gun onto Mr. Booker. So that's, from my reading, the only evidence we have of how he was handling the gun. But it was certainly within the jury's purview to find malice.
But there was some testimony of pointing it in a general direction as well. And so, and my understanding, this was a shotgun, correct?
Correct.
And so if a juror understood, you know, I don't know if there was testimony of it being described differently than a pistol, but obviously the jury had the ability to make that determination that that conduct could show malice or not. It was free.
Or recklessness.
Or recklessness, but it was free for the jury and it was presented, and it was also free for the defendant to challenge that with other testimony other than Booker's testimony as well, correct?
That's correct, yes. And I believe they brought the actual weapon into the courtroom, but if not, they had pictures of it, and that's in the record here. The final point that I wanted to make on this, kind of the third issue that we were just talking about, is, and it goes to prejudice, is our Supreme Court has said that a trial court cures any prejudice resulting from a prosecutor's misstatements of law by giving a proper instruction. And here, the trial court gave the pattern jury instruction on accident. So, under that clear case law.
And lesser included too.
Correct, yes.
That would have allowed the jury to disregard the firearm.
Yes. Yeah, the court gave the accident instruction on volume 14, page 2289. And I quoted it in my brief. It's almost word for word. You know, there's or a strenuous, the or something. But it is the pattern jury instruction. And under, clear case law, that's Goss from our Supreme Court. Any prejudice was cured. I'm happy to answer any of the court's questions, but unless there are none, I'll simply say that we ask the court to affirm. Thank you.
We'll hear from the appellant, and you have a little over 7 minutes.
Thank you.
Yeah, I guess you heard my concern, and I don't know if you can address it. It seems to me the jury found he didn't mean to do it, and the only thing you're complaining about was the jury didn't get to hear more evidence that he didn't mean to do it. So how is he prejudiced? It seemed to me the jury, it really turned on whether they thought he was engaging in an inherently dangerous activity.
Right, and that's a question, right? The jury found that he was engaged in an inherently dangerous activity. That doesn't mean holding a gun. Holding a gun isn't inherently dangerous. It's what was he doing with it?
So what testimony was not let in? That did Mr. Booker, was he not allowed to, was there some statement he made? It was an accident and he wasn't even pointing it at her. Or was there some extra statement? Or was it just that it was an accident? He didn't mean to do it? 'Cause it
There
seemed
was.
like-
Mr.
Okay.
Booker said the gun just goes off. He told that to a police officer on the body cam video.
And he was
He
not allowed
in
to
the
say
room.
that. And that was
Correct.
not allowed to come
It-
in.
And he didn't say it in his testimony. He said it minutes after the shooting happened, right? It was a contemporaneous perception that he had based on everything he saw, not just Mr. Suther's
The
face.
gun just went off.
The gun just went off.
And-
He said it goes off, is what he said.
And they were not allowed to offer that statement.
Correct. And to your question before, Mr. Suthers did testify himself about what he was doing. He said he was holding the gun and he was antsy because he was waiting for them to finish with the crack pipe or whatever it was he wanted, and the gun slipped a little bit and he was adjusting it and it went off. He also, there was evidence that he is able to pull a trigger, but he has some paralysis in his fingers. So there was evidence that he put into the record himself that gave the jury something to find, that it was not inherently dangerous. He was standing there and he was holding a gun and it accidentally went off.
I guess, counsel, with those statements, and I saw that, but now that you bring it up, couldn't a juror find that his condition with his extremities, holding a gun for whatever period of time, in a room where drugs are being consumed, and the fact that he's getting antsy, could potentially be inherently dangerous within itself?
It could, right? But the question is the weight of the evidence and that the jury was given. They didn't get a full picture. They got pieces. They got Mr. Suther's testimony, which is self-serving, as everyone can acknowledge. That doesn't mean it wasn't true, but it also, people can have some doubts, is he really telling the truth? And what you're missing is, one, his statement, I didn't mean to do it, immediately in the thick of the action. And Mr. Booker said, minutes after it happened, that Mr. Suthers said that statement. That's offered for corroboration, not for the truth. But it bolsters Mr. Suthers' own testimony. He said, I said that, and Mr. Booker would have said, yeah, he said that.
So I guess where do we get for the threshold, and there's been some discussion in some of our case law, but where do we get to the threshold of cumulative versus complying with our requirements of not letting, as the state has alluded to, not letting lay witness testify to, intent, whether that's, using actus reus to describe what the intent was or not. Where do we get to cumulative versus allowing testimony that could be corroborative?
Right. If you don't like the shorthand statement of fact, and I can talk about that too, you have corroborative evidence, what I was just saying. Mr. Booker said he didn't mean it. You also have, I lost my train of thought, sorry. The weight of it, because Mr. Suthers is saying self-serving statements, and especially because the state attacked him for not saying it before, the fact that he said it at the time, the state knew that Mr. Booker reported him saying at the time 4 times on that videotape, I didn't mean to do it, and then for the state to turn around and say, well, he's just coming in with this new story right now. All that goes immediately to Mr. Suthers' credibility about whether this was accidental or not. It's the heart of the whole case. And so to try and argue that it's not prejudicial, especially under the constitutional standard, how can, any evidence could have shifted the jury's way of thinking about this.
How do you respond to Mr. Van's argument that even if we agree it was error, and even if we agree it was prejudicial, that the giving of the accident instruction cured any error and prejudice?
I think the state's argument was that cured the prejudice from the improper argument that we contended in issue 3. The weight of evidence given to the jury affects how they're going to decide, right? They're deciding between not guilty and a little bit negligent and very reckless. Those
But
were their...
and Mr. Van represented that Judge Gorham gave, in effect, the pattern jury instruction on accident.
Correct.
So basically, I guess it squarely put the issue before the jury.
Correct.
So, but you're saying that that wouldn't cure, even if we would agree with you, there was some error or prejudice in Judge Gordon's ruling on the eliminate motion, that wouldn't cure it?
No, because it's the weight of the evidence that comes in. It's Mr. Souther's right to put on the 911 call, you know, made by the only person in the room besides him who said this was an accident.
Well,
You know, the gun just went off.
There were 3 other people in the room. One of them's dead,
Yeah.
and the other 2 people, we won't know where they are.
Well, and they actually weren't in the room. They were in the next room. So they were, the Philly and Bob, the person whose apartment it was, wasn't there.
They were in the room when the defendant first entered with a gun.
Correct.
And there was some comment made, don't bring a gun in here.
Well, so what Mr. Souther said is, I came in and I was joking around with Philly. What Mr. Booker said was, I couldn't hear what anybody was saying in the next room. That's the testimony at trial. So Mr. Southers is really the only person who talked about what happened in the first room.
Well, did the jury hear that the victim had gone out to confront the defendant and had come back and told Mr. Booker that the defendant had struck her?
Yes, we talked about that before.
You can take a minute to wrap up.
Okay. I want to talk to you quickly about the shorthand statement of fact. I submitted State versus McVeigh, which is another case allowing a shorthand statement of fact from a witness who says, I observed this, and it was, I think he meant to do it. There's also Lassane, which is quoted in the brief, and those stand against the state's 1800s case, which was decided before the rules of evidence came along. I would ask that you find the exclusion of this evidence was enormously prejudicial to Mr. Souther's defense of accident because of the immediacy of the impression of the people who were in the room being kept from the jury, and the corroborative statements that Mr. Souther's made on top of the state's arguing that he never said anything like that, contrary to what they knew was true. For all those reasons, Mr. Souther's is entitled to a new trial. Thank you for your time.
I have one question before you leave. Are you challenging the defendant's conviction on either misdemeanor B&E or possession of firearm by a felon?
No,
So those are not before the court?
they're not before the court in the
Thank you.
brief. Thank you.
Thank you for your arguments. That was excellent. Thank you. Mr. Clerk?
All rise. This session of the North Carolina Court of Appeals is adjourned.
I know. No, you didn't.
I don't think I did.
No.